Good. Hello and greetings, everyone. Welcome back again for another one of our drop-in sessions. I hope that you were all here last week because this is a bit of a continuation from those classes about negotiation. And as if you were here last week, you saw a lot of terms and a lot of background material. We're going to get into some more tip-based advice for you. Uh, on today's class, I'm going to mute someone. Aya. Okay, can you hear me? I somehow muted myself. I apologize. Let's see. There we go. Okay, welcome everyone again. As everyone's slowly coming into the room, we've got 24 people here. That's a good start. Like I said, we'll have a little bit of a recap, but before we do, let's go through some of our standard background information. This is me. My name's Jeff Keiser. I'm an American attorney. I've been an attorney for about 15 years now. I've been teaching these classes for a while now, so I feel like you all know me better than I know you. Uh, I've worked on some big cases, but I've worked in all sorts of fields of law. I am currently in Da Nang, Vietnam, where I'm living and have been for about the last, what has it been, 9 months now. It's wonderful here because they don't have COVID so badly, and life is more or less normal. Um, I've also been teaching English for the last few years. As you know, I think as all of you know, I do see some familiar names. Um, but before we start, if you could please send me your name, your email address, and your law firm in the chat window, I would really appreciate it. It helps us keep track of who's here, who's participating, and it allows us to reach out to you in the future for other classes. Maybe you have a topic that you'd like us to discuss. Let us know. We'd be more than happy to try to work it in. Also, if you come to our website, that's legalwriting.eu for European Union. There's a lot of great resources here for lawyers in any field. We're also looking for people to help write for our blog or to help complete sections. So if you feel like writing, if you're a writer, please let us know if you want to get involved. I know you're all very, very, very busy people. So I'm aware you may not have time, but if you do, if you're a legal writing nerd like I am, let us know and we'll get you involved in one way or another. And if not, just check out our website. It's a very cool site with lots of good stuff for any kind of lawyer. All right, next is our upcoming schedule of classes. Next week is about LinkedIn and other social media and how lawyers can use this to our benefit. We have some good stuff. I think it'll be a bit of a fun class. I need to work it up just a little bit myself. After that, we're going to go into how to write a legal letter, an excellent legal letter, and then back to knowing your audience. I think some of you may have seen that class before. We throw in some repeats as these classes aren't a continuum. You can come and go as you see fit without missing too much. If you've been here before, and like I said, I think a lot of you have been, you know that I start off with a quote of the day. And this one comes from Nelson Mandela. No problem is so deep that it cannot be overcome, given the will of all parties through discussion and negotiation, rather than force and violence. I think that's a good lesson for us all, that negotiation is always better than violence. And there are people in our historic past that we can use to teach us those universal truths. Although I have a second quote for you, a little bit more violent, I suppose. And this is the root of negotiation. And this comes from Don Corleone in The Godfather, one of the greatest movies of all time. And it's, I'm gonna make him an offer he can't refuse. And if you've seen the movie, you know exactly the the context in negotiation of what he's actually saying. All right, hey, we're finally here. That's great. Um, but before we get into the new stuff, I'm going to give us just a minute or two to kind of think about a lot of what we talked about yesterday, or last week, excuse me, not yesterday. And really, we're talking about two kinds of negotiations. One is a win-lose kind of negotiation where you don't care about the other side. It's all about how well you do. You have different interests. It's a short-term relationship. I always think of a market where you might bargain on the price of something as a great example for this, where I don't really care about the person selling me the goods. They certainly don't care too much about me. The only thing that really matters is the price. On the other side is you have integrative, which is win-win, and that's what I like personally. I like to see things where everyone is happy at the end of the day, and our motivations are both our own and more of a collective motivation. I find that this is what we do as lawyers for the most part when we're negotiating. I'm not saying that the win-lose is a bad way to do it in all circumstances, but I think for the most part, we all get better deals when we try to work together. Otherwise, it's a lot of take it or leave it, and people might just leave it. And that's always disappointing when that happens. But I think this is a good short summary of what we talked about last week. I hope this makes sense. And if not, and I'll say this before we go any further, stop me if I am not making sense. I have been known to go too fast or speak too quickly, or maybe not have a complete thought all the time. These online lectures are difficult because I'm unable to read the room, to look around and see either bored faces or confused faces or anything. So if I tell a joke that you like, give me a thumbs up in the chat window. If I say something that you don't understand, ask a question. If we don't have time right then, we'll likely have time to come back at the end of the day, at the end of our class. And if we don't have that, I can answer questions via email at any time. Also, if there's a tech issue, let me know. As it stands, I'm looking into my laptop screen, and I don't really know all the time if things aren't working perfectly. So please, somebody give me a sign if there's a problem of any kind, okay? Thank you so much. We're gonna get into it. All right, finally. If you remember last week, I started off with a bunch of these little true-false questions about cultural norms in negotiation. These are kind of fun, I think. They're true-false, and I'm not expecting you to know the answer, but I'm expecting you to guess your best guess at whether or not these are true or false. So the Chinese won't spend much time gathering and exchanging information, since they are often eager to get started with the bargaining exchange. Some people may take a lot of time doing that. Other people may not. So what do you think? Do you think this is a true statement or a false statement? Okay, we're getting some answers. Excellent. And I absolutely understand it if you're just kind of listening in the background or doing other things and don't want to play along. I get it. I was a lawyer. I was sitting in these seminars not too long ago. Uh-oh. Okay, but now we've got a few answers and we've got a dispute. We got a lot of truths and a lot of falses. The answer is false. In China, they may try to find out a lot of information about you as the negotiator, but there won't be a traditional exchange of information. I think we'll talk about this exchange of information a little bit later, but I like to think of this almost like the discovery process in a lawsuit. Sometimes there's a lot of it, and sometimes it's a real fight to get even the littlest bit. Okay, good work. Like I said, these are more fun, and I hope you find them interesting as I do. Okay, what about Brazil? In Brazil, when making decisions, Brazilians usually look at the specifics of a situation rather than universal rules. What do you think? Aha, again, look at this. This is I think this is fun because again, we have disputes. The answer here is true. So the people that said true were in the minority, and they were correct. And this is a little bit more esoteric, where we're talking about the cultures. Like Americans or Germans like to think of kind of the global impact of a deal more than the situational impact. Evidently, Brazilians are the other way. I thought that one was an interesting one, just because I've never really dealt with Brazilians one-on-one. I've had some Brazilian friends, but I've never thought of it like this. All right, we'll do one more. I don't like that one. Let's do one more. Okay, here's a good one. Negotiators in Israel often use silence as a pressure tactic to obtain further concessions. I know my girlfriend certainly does that on a regular basis, and it's quite effective. All right. I see a couple trues, but again, this is false. Silence is rare in conversations among Israelis, and they don't usually use it as a tactic either. Now, I give you all of these true falses, but I'm not going to say that they're ever a universal. There can be Israelis or Brazilians or whoever or Chinese that have different desires, and that's more of an individual analysis. This is more of a global consensus by experts that have studied it far more than I have. But look, yay, there will be more of those in the future. So I hope you like them, and we'll get to them in due time. But we're gonna finally get into some tips, and I think I've got 6 main tips here to go through. And this is how to negotiate. The first is to prepare, and this sounds obvious, right? If you want to do anything well, you should prepare for it. And if we were going to a trial, we would certainly prepare for that. Even for a big, client meeting, we might prepare to a certain degree. I have seen this with my own eyes, that when it comes time to negotiate, lawyers like to sometimes like to just fly by the seat of their pants and make it up as they go without the preparation. And this can become a real problem. Certainly a negotiation session or a mediation is just as important to our clients as a trial. So we should try to prepare for them as if they're equally important. Now, when we're preparing, there's 4 things I want you to think about. I want you to think about preparing for the law. We'll talk about that in a second, and all of these. We want to prepare your client. This can be the most difficult part of being a lawyer. We want to think about our strengths and weaknesses, not just of our case, but of the other side's case as well. And finally, we want to think of the consequences for our negotiation style and our tactics and where that's going to get us. But first, we want to think about preparing for the law. And this is all based in someone that might work on different kinds of cases. When I was a personal injury lawyer for many years, I was an expert in that field. And you could ask me anything and it would just come right off my head, and I would know what cases were important and what statutes were important. I really could get into it. At the same time, if you asked me about a divorce case or a child custody case, I know next to nothing. I've never really worked in that part of the law, but a little bit. And when I did, I had to prepare for that. So for any negotiation, you need to know what the law is, what rules apply to your negotiation, and how to use those rules to your benefit. Now, your client, and when I said this was a difficult thing to do, what did I mean there? Okay. Clients are, we love them, we need them. They are the most important person in our law firm because they pay us money and they allow our bosses to pay us money, and they're the reason that we're there. But they often don't know much about the legal process, about their case, about much. Some do. If you have high-level corporate clients, they may have a pretty good understanding of how things work. That being said, we can't count on that. So we need to talk to our clients. So we need to learn their expectations. We need to tell them if those expectations are not realistic or under realistic, I suppose is a word. We need to get them ready for this. Think about it this way. If you were at trial and you were putting your client on the stand to testify, you would spend days preparing them for that. Really, this is no different. We want your client, the most important person in the business, to understand what's happening. So what we want to do is we want to ask the client, are they looking for money, or are they looking for a situation to be done right? Injunctive relief, for example. What's the time frame for the client? Sometimes maybe they have a cash crunch and they need money yesterday. Maybe they have years. They just want this to keep going as almost a retirement plan. What's their bottom line? Where's the client going to be happy or unhappy? These are the things that we need to know if we're going to negotiate at all. Importantly, is that minimum position realistic at all? This is the hard thing. I had personal injury cases that where the clients unfortunately had access to Google and kept seeing awards in other cases for millions of dollars, and somehow they believed that they were entitled to millions of dollars. So a lot of my job, and presumably yours, is explaining to the clients that that case is different. Maybe it's in a different jurisdiction. Maybe there's other things at play. I have explained to so many clients and frankly, friends and acquaintances that they can't generally sue just because they were harmed in some way. Damages are what we look for to sue. So prepare your client, get them up to speed on what's happening. And my top tip here, more important than just about anything, if your client has an unrealistic expectation of the case or the negotiation or the deal or anything at all, it's time to sit them down and have a real serious discussion with them. I've always been the lawyer that likes to underpromise and over-deliver. So, it's okay to give a client a potential range that they may recover in a personal injury case, or a lowest or highest price in a contract negotiation. But we need to get our client to at least a basis of being reasonable. Otherwise, we're not going to be successful. Okay, we need to prepare the strengths and the weaknesses of our case. And that partially involves the law, but it also means that we should prepare for the facts of our case and what we may be defending or prosecuting if we're on the other side of things. And that's really a fact-intensive analysis that I trust you all to do on your own. But these are things that we need to prepare before we start negotiating. So think about that. Think about where the other side is coming from and where you're coming from. One simple tool to do this effectively is to literally make a pro and con list, just like you were trying to make a decision on, I don't know, what apartment to live in. And if you go through and list the defense attorney pros and the prosecution side pros, you sit there and you can kind of work out how these things will play out. You can see where you need to focus your work and what part of your work you need to highlight. And throughout this course, I've got some general tips. This is one of those pages. I hope this works from a layout perspective. I was being slightly overly creative with my PowerPoint. And here are just a few real basics about negotiation generally. Negotiation can only happen if the sides are willing to communicate. It's a two-way street every way. And I guess unless you want to do the pure win-lose communication where you're telling one thing and that's how it is, good communication, good negotiation is necessary. Sorry, good communication is necessary for good communication. Apologies, my words. And with regards to that communication, we need to listen to the other side. We tend to sometimes get so competitive in negotiations that we're unwilling or unable to really listen to the other side. For the most part, their perspectives are they're not crazy. They have reasons for their positions. And what we want to do is learn why they want these things, why their interests are so important. So, of course, we have to be careful with our information. We don't want to give the other side everything and not get anything in return. But when we do have a good sequence of communication, we must listen to them. And we must realize where concessions must be made, what's a deal breaker and what isn't. That gives us a real good framework for our negotiation going forward. Okay, and in the same vein, information is key. We may know why they want something, and maybe we didn't understand it before. Maybe they are selling us a car, but the car must be purple. That sounds ridiculous to me, and I don't understand it. But maybe the seller's mother's dying wish was that the car was purple. That's ridiculous, I agree. But if we have that information, it will help us make a better negotiation. Maybe we'll say, okay, purple is fine, but I want to pay $1,000 less because I don't love purple. These are the things that can help us complete a better negotiation. All right. The last thing to prepare for are the consequences. And this is really like, we look at our possible outcomes. Many people, you should be familiar with the term best case scenario or worst case scenario. And those should definitely be on your list. There are thousands of scenarios somewhere between the worst and the best. So what you want to do is start thinking about that. What are the possible outcomes? And of course, one of those possible outcomes is no deal, that you walk away and say, we're unable to make a deal. So before you get into to do this, ask yourself these questions. One, what are your chances of winning the case if it goes to court? Now, we like to think that we can predict what a court would do, but my experience has taught me that that's rarely the case. It's more like a sports bet where you might be 75% sure of how a court will decide something, but I would not recommend that you ever guarantee how a court will decide anything. But if the answer to that question is yes, if you will definitely win this case if it goes to court, you are in a great position to negotiate. And you can say, I'm not going to make many concessions because I could win it at trial. The other side would know this as well, or should analyze this as well. And it puts them in a better position to evaluate just how much they're going to have to pay. Then, after that, start thinking about what's the best outcome for your client. With a sales deal, that's pretty easy. It's how many thousands or millions of of whatevers, dollars, euros, pounds, rupees, whatever, that is the best potential outcome for your client. Another thing to consider is, what's the best outcome for your client if there's no deal, if your client has to go outside this deal to get what they want? So that would mean if I wanted to buy a car and I wanted to buy this car from this dealer, how much does that same car cost at another dealer? Again, the next is, what's the worst case scenario? For most negotiations, that's going to be the bottom line. And getting an honest answer on what the bottom line is a very difficult thing to do, because if you get an offer that's just slightly under your bottom line, sometimes it's very difficult to say no. And then, yes, what is the absolute worst case scenario for your client? And think about these. Maybe have a discussion with a colleague. Maybe this is a good kind of team building exercise to think about these things. How good can it be? How bad can it be? Okay, I know that was a lot on one tip. I'm fully aware that was a lot. The rest are a little bit shorter. And now I want to just talk a little bit about tactics. There are more negotiation tactics than we have time to discuss in probably all of these classes combined. And here's the reality, is that we've used them. We've seen them and we've used them, most of them, in our day-to-day life. I have a list on the next slide of common tactics. And we won't go through them all, but you can look at them and say, huh, I remember seeing that. Maybe it was just on a TV show or a movie, but it's good to think about the different tactics that are out there. As people, not just as lawyers, but just as people, we tend to get stuck on a handful of tactics that work for us. We don't tend to open our toolbox very much and try to figure out a new way. I recommend doing this. I'm not saying you have to use all of these tactics, but open the door to some others. We often think that we know the best way, but I can assure you, even the best negotiators in the world are learning new tactics every day. So here's a list, and like I said, we could expand this list. I'm going to leave this up for a minute or two because there's a lot there. Like I said, I won't go through all of these, but if you have any questions about specific ones, I'll be happy to discuss. One of my favorite ones that you see sometimes in some situations is number 5 here, the little old country lawyer. And this is where you pretend to be a very unsophisticated, unsmart lawyer that survived on old wives' tales and experience more than hardcore fighting. I have dealt with so many of these lawyers that pretend like they're stupid. They may have a funny Southern accent or something of that nature, but they are the best lawyers and the best negotiators in the world, I would say. They use these devices to their benefit. Bluffing. This is a standard poker tactic in the card game, where you tell them that you have something that you don't have. There can certainly be negative consequences to trying to do that kind of thing. I have to catch a flight, number 12, for example. That's just putting a time crunch pressure. That's not undifferent than what we do a lot in our letters when we say that if we don't hear a response by February 4th at 5 p.m., I will assume that you want to go to trial or something like that. that in itself is a negotiation tactic. So if you've written a legal letter and you've put a deadline in it, that's a tactic to consider. Take it or leave it. We get that a lot in small sales, which is the price is $50. If you want the whatever it is, you pay me $50 or you go away. End of story. That works for some people. Let's see here. I'm trying to see if there's anything else that we should mention. Does anyone have any other questions about any of these before I move on? Okay, I will take silence as a yes. You see, there is a negotiation tactic. I put the pressure on you to answer, and I'm accepting how I believe your answer would be. One tactic. Okay, let's see. We have a question here, and this is a good question. I'm actually going to see if I can get a great answer. If I could type, that would be better. Nibbling is a funny one. Nah. I'm giving a quick cut and paste from our friend Google. One moment. Okay. So they're calling this the most common tactic used on salespeople. The same way that a mouse might nibble at a piece of cheese with small bites until it's completely gone, nibbling is asking for small items, one at a time, and getting agreement on each until you've gotten a lot. So I'll use my car example again. It's a boring example, I know, but I think keeping it simple is a good idea, where I go and I'll say, okay, I'll buy this car for $10,000. But I want the upgraded stereo system, and making that a small nibble. And then when he says yes, I'll be like, well, I also want the sunroof, and I want the floor mats and all those little things that add up when you buy a car. I hope that makes sense and answers your question. If you're curious about any of these, feel free to ask me. They usually have really good answers on Google if you need a short, simple answer. But like I said, I'm always here to assist. One thing before I go on is number 25. Now, lawyers have a bad reputation for using a lot of personal attacks and ad hominem in negotiations or intimidation tactics. I'm not going to lie and say that these don't work sometimes. They do work sometimes. I personally find them a bit distasteful, and I find that they prevent working with people in the future. We'll talk about this a little bit later as well, but your reputation as a lawyer is your most important asset. And if you're known as a lawyer that yells and screams and calls people names and thinks everyone's an idiot, you're going to end up being a less successful lawyer than if you treat people with respect and save the name calling for the happy hour after work. That's my own personal advice. That being said, I've been a part of negotiations that got to that level, and the deals go through sometimes. And usually afterwards, there's an awful lot of, I'm so sorry, I was a jerk, and everyone was a jerk, and you can sometimes salvage the relationship, but I'm not sure that it's worth risking. So you see this in TV and movies a lot, where the lawyers are screaming at opposing counsel and calling them names. I won't lie, sometimes this works. It all depends on your position in life. So take that with whatever you will, and something to maybe try to avoid. This is a lot of text, and I guess what I'm really trying to say here is that in any negotiation, never close the door. Your goal, obviously, in a negotiation is to make your deal happen, whatever that deal is. And there may be several unsuccessful meetings before you can get to an agreement. So never slam the door closed and say, no deal, we're going to quit. I should be careful because you should never say never. I'm sure there are times in which that is a necessary situation. But if you can't close the deal at the mediation or at a negotiation session, then try to leave an opening. You can do this with a time frame. Like I just said, you can give the other side a week or 10 days or whatever to think about it. They may reject the offer outright at that moment, but you can still give them time to think about it. I have seen more than one negotiation come back to life after one angry partner or one angry client left and took a day to think about the real world situations. And so their options were basically litigate and maybe lose or take what they had now. And for them, it ended up being better to take the offer on the table. You just want to think about these things, that even in the darkest hours of a negotiation, even in that time where you may think it's an impossibility, deals can happen. Even the most contentious deals can sometimes, both parties can just wake up and have an epiphany and say, like, this isn't worth fighting over so much. Let's stop. So that's tip number 3, is always try to think about leaving that door open. Okay, here's a few more kind of general negotiation tips. I hope this is good. Like I said, I'm interspersing a few of these throughout, and otherwise it would just get boring. This should go without saying, but I feel like I should say it. And that's to respect the negotiation process. To not expect unreasonable resolutions to a negotiation. Like, think about the other side. The strengths and weaknesses analysis that I mentioned earlier is the best way to do this. It's best to not think of your opposition as the enemy. And if we know their positions and their interests, that shows us not just the what they want, but the why they want. So try to respect the process. Yes, we all get angry at opposing counsel and opposing clients and our own clients. Leave that out of the negotiation itself. Go with your friends after work to have a cocktail. That's where you can complain about this kind of thing. And I may have said this before, and I will probably say it again. This is a two-way street. At best, you know one side of the story. Your client will come to you with all sorts of facts and allegations, just like opposing counsel's client, the opposition client will give them their side of the story. It's dangerous to believe your client 100% of the time on 100% of what they say. They're telling you their side of the story. And it's an old proverb or whatever to say that the reality, the truth, is always somewhere in the middle. So think about that and try to get to that middle, because that's where your negotiation is going to land. To get there, ask questions. I've said many times, there's no such thing as a dumb question. And that's true. I mean, there are questions that people can ask that might sound dumb. But if there's a piece of information that could help you solve the problem or solve the negotiation, then absolutely ask questions. get that information and be smart about it. If you ask a question that they're not answering fully, this could be an important point to work on. Maybe they're trying to hide something. Maybe that's where you win. But if they're not willing to tell you a fact or something about their negotiation, there's a reason for it. Body language is important if you're having a face-to-face meeting. I feel bad for body language experts since 2020 because we see a lot less of it. There are books about this, and there's probably some very interesting cultural norms about this as well. But body language is an excellent way to show how communication works. Like I said at the very beginning of this class, this is difficult for me because I can't look at your faces and I can't tell whether you're nodding in agreement or shaking your head in disagreement or rolling your eyes at the things I say. I hope not. Or are asleep on your desk. If I could see how you're responding to this lecture that I'm giving right now, I would know so much more. And I would probably tailor my lesson plan to get the best happy smiling looks out of your faces. So that's something to always think about if we ever go back to having face-to-face meetings anyway. I kind of think we will. I think it will take a little time, but I think we'll get back there. And like I said earlier, good preparation. Research the law, understand the issue, be clear on your client's wants and needs. Okay, those are just some basic background tips. I hope you find them helpful. All right, back to our fun stuff. All right, we only have 19 minutes to go, and we may be a little bit behind schedule. So what do you think? True or false? In the Netherlands, a person sucking their thumb is signaling that he or she does not believe you. Hopefully false. Okay, it looks like everybody agrees that this is no, it is true. I find this really hilarious, to be honest. I've been to the Netherlands, but only for a couple days, and I did not experience this. But this is true. And everyone's expectations were wrong. That was kind of my goal, is to show that there's some things that don't make sense. Now, I wouldn't recommend walking around Amsterdam sucking your thumb to show that you don't believe people until you understand how this fully works, because it could be considered rude. I honestly don't know that much about this one, but it's true. Okay. What about Mexico? If a negotiation in Mexico gets stuck in a dispute over a smaller detail, you may be able to resolve it quickly by appealing to your personal relationship with the counterpart. Everyone got this one right. Excellent. Yeah, and I think this works in a lot of places, not just Mexico. It's the my friend, why can't we get together on this discussion? You see this a lot in local markets in Asia or where you're supposed to bargain. And when you're supposed to give them a very good price, you're the best of friends. My friend, come talk to me. But in reality, there is very little friendship here. Okay, what about Saudi Arabia? Contracts in Saudi Arabia are expected to include lots and lots of detail and take a long time to create and agree to. Okay, let's see. We've got a couple answers coming in. Yes, everybody seems to agree on this one. False. I guess in Saudi Arabia, the contracts are very simple and high level. That sounds like a challenging place to be a lawyer. But I've always been the person to be very detailed in these things. So writing a, a vague and low level contract seems difficult to me. Okay, tip number 4. We still got 3 tips to go and only 15 minutes. Oh no. Uh, and this kind of is the flip side to keeping the door open to negotiation. And this is when you have a deal, paper it. Get those signatures. Because even if you have an oral agreement, it's not as enforceable as a signed agreement. So I guess what I'm saying is usually when a big negotiation is concluded, your law firm may throw a big party at some fancy bar or restaurant with $20 cocktails and spend all the money they have. I say don't high five everyone until you have a signed agreement or a contract or whatever your negotiation is. I've seen more than one deal fall through, even though the parties generally agreed. So once you get that agreement, make sure you can prove it happened. And if you're ever into mediations, sometimes the mediator may offer to write the memorandum. Sometimes opposing counsel will offer to write the memorandum. I'm always in favor of getting work off of my desk. I really always am. But this is dangerous because this is our deal. And we want to control the words that we use to explain it. So don't take the lazy way out and make sure that you're involved. Tip number 5, and this is a good one. And it's a difficult one for a lot of lawyers. And that's to be ethical when we're negotiating. There are a lot of those tactics on that slide about a few back ago with all of the list of the tactics that aren't necessarily ethical. And that might be bending the truth about your position or the other side's position. I think we all know and we can all agree that lying is morally wrong. I think we can all agree to that statement. That being said, that there are times as a lawyer where we might need to, let's not say lie, but let's say well, a nicer word for lie. If you want to help me, let me know. But we have to hide the truth. We have to obfuscate things, or we have to fib. Thank you. Or we have to pretend that we're not lying. We rationalize this a lot of ways. BS is another good one. At the end of the day, our reputations are what we have. And if our names get known, whether it's in our law firm or in our city, as someone that doesn't tell the truth, that's going to make future negotiations very difficult. We always want to come into a negotiation as a neutral, almost as a facilitator. And if our reputation is that we're full of BS or we lie all the time, we're not going to be very successful. Now, that being said, the deal might be big enough. We may not care so much about dealing with them in the future that it's worth it. It's worth deceiving in one way or another. Now, I'm not a religious figure, although some would think so. I'm not here to say what's right and wrong. I think we need to be careful with this. And to me, I was always raised with the golden rule, and that is to treat others like we want to be treated. And I think we can all agree that we would be really upset and really angry if we found out that the other side was lying to us. So I would recommend very strongly to not do that as much as you possibly can. each negotiation is its own special animal, and so they all have their own path. Um, but so sometimes deception is required. We may need to deceive our own clients sometimes. But as a general rule, I would recommend against it. I think it's an interesting thing here that they've done research that shows that people generally we think ourselves as being more ethical than other people, but this isn't the case, because that would be impossible for everyone to be more ethical than everyone else. We're all flawed people with with our own special set of baggage. We all know when lying is maybe acceptable. I wouldn't say okay. And I think you're all smart enough people to know where those lines are, or at least to understand what those lines are. And it's something to think about for the future. Maybe we should have an ethics class, one of these sessions. I don't know. If anyone's interested, let me know. We could talk all about the ethics of being a lawyer. That could be kind of fun. Anyway, that's a tip, and it's something just to think about, is to remember that at the end of the day, we're all people, and we're all trying to get our clients the best deal possible. And we know the difference between telling a lie like, no, your tie is a great, beautiful tie that you're wearing today, and something that could really harm the other side. Anyway, something for you to consider as we go forward. Our last tip, and then we have some fun, a couple exercises. I don't know how much time we'll have. And this is the exchange of information. And a good rule of thumb here is to make sure that you're giving as much information as you're receiving. This is what I mentioned earlier when I said there's kind of a discovery process when it comes to a good negotiation. And we'll even use my simple buying a car example. Again, I know it's not the best, but it's a simple example that can illustrate this. If I go and look at a car, I don't know much about that car. Maybe I need to go and ask for what the dealer paid for the car, what the average price for this car is, how many cars have they sold in the last month, how many cars do they have in stock. The more we know about the other side, the easier it is to negotiate. And the vice versa is true. The more they know, the easier it is for them to negotiate. Again, we don't want to make it easy for them all the time, but information is just key. So here's a famous old example. This comes from some negotiating teachers from 100 years ago. I could look it up if you're interested. And it's to imagine the case of two brothers fighting over the last remaining orange in the house. Now, the mother is sick of their fighting and wants to end this dispute. So she grabs the orange, cuts it in half, and gives half to each child. This is a pretty easy compromise, right? This is a quick solution. King Solomon in the Bible did this, I believe. King David said, like I said, I'm sorry, I won't go biblical. But if she'd only asked why the sons wanted the orange, she would have learned that one just needed the juice and didn't need the peel, and the other brother wanted the peel just for his art project. So both brothers could have walked away happy, win-win, 100%, without any compromise at all. So I guess that's that. So just think about the information that can help you get a better deal and ask for it. All right, last page of general tips. Last week, the type of negotiator you are, that test that some of you took, one of them was a principled negotiator. And those are people that hold to their principles no matter what. And I would say to hold firm to your principles, but only if you can defend them. It's like being asked, why did you do this? And answering the question, because I wanted to. That's not a good answer. So it's good to have principles. It's good to say, I don't lie in negotiations. And that's a pretty easy one to defend. But others you may want to waver from time to time. This is a good one. And a lot of people think that they can be aggressive in negotiation, and that's their tactic. It's important to not let them get under your skin or intimidate you. They see this as the best way to do their job. Your job is to show them and your client why it isn't the best job. There's a lot of ways to deal with an aggressive person. And a lot of times it may just be to walk away from that session and say, I'd be willing to deal with you when you're calmer. And that may even, in a legal case, a dispute, you could even end up calling the judge and saying, Judge, this person's unwilling to talk without screaming, and getting some people involved. But don't be intimidated by this. It's really easy to do this, especially as a young lawyer. Just remember, they're doing their job, and it's okay for you to do your job. Be prepared to compromise, but stay consistent. So when we're compromising, you may or may not, depending on your situation, want to tell them why you're willing to compromise on this point. It opens the door in a way to not compromise on another point. No matter what, stay consistent on your issues. If the color of car is your number one point, then don't compromise from it. Be prepared to walk away if the deal is unacceptable. This sucks. I always hate it when you've spent a lot of time trying to work out a deal and it becomes clear that it's not going to happen. And if it did happen, your client would be very unhappy. It's okay to say, I don't think we can make this deal happen. And you try as hard as you can, as long as you can, but be prepared to walk away. If this isn't, indeed, it's a tactic. It's a tactic to negotiate, is to say, I'm going to walk away from this deal unless you say yes. So that's okay to do. Afterwards, after your negotiation, I think it's a great idea to think about, to do a post-mortem on your negotiation. Look at things where you were successful, what tactics you used, what information you had, what made this situation work, but also work on these other things that didn't work. Like when I went to the other side with this offer, they got really upset and didn't like it, and try to figure out why. This will teach you to become a better and better negotiator as we go on. Okay, guys, we only have about a minute left, but I have a few questions. Now, I will be sending this PowerPoint out immediately after class, so you can look at these later. But there's some pretty basic true or false negotiation things. I think they're pretty easy. I won't ask for your answers or anything, but you may want to take a look at them as you review. I got 10 questions. If you need the answers, please do let me know. And I even have some more of these for you to review, but I will save that until you look at them so you can see your surprises. Okay, guys, this has been an awful lot of negotiation for the last 2 weeks. I hope you've enjoyed it. I know these two classes have been a lot of me talking, and I find that a little bit less fun. So I think that I'm going to try to get you guys to participate a little bit more next week, which is all about social media for lawyers. And I have some funny stories about clients and social media to tell you. And I think it'll be a fun class. I'm getting to work on that right after this one. So everybody, go have a wonderful rest of the week. Be the brilliant lawyers I know you all are. If you ever have questions, feel free to shoot me an email. I'm happy to answer them if I can, and if it's an impossible question, I'll tell you that. If you have legal issues or legal English issues throughout your week, just say the word. I am really here to help you guys. And like I said earlier, if there are any classes that you would like in the future, let me or Josh know. We love to make specialized classes, whether they're one of these drop-in sessions or a more one-on-one specialized course. We do that all the time. And finally, if you enjoy these classes, please do tell your HR representatives. Um, like I wish I could get more feedback on these classes, and we'd love to continue doing them, but we need you to tell your HR reps that you love them and I'm a genius and you're paying far less than anywhere else. Without anything else, I hope you guys have a great day. Take care, and I will see you next week.